Before we vote on this one, let me make a couple comments. Um, First of all, I believe now, as I've always believed. I mean, marriage is one man and one woman, and I think that's the way that it's been in the whole history of mankind up until the last 15 years. And the whole process that's played out across the country has been kind of frustrating to me because I have never thought that marriage was a constitutional issue, a U.S. constitutional issue, right? I don't think that the federal courts have any business in this because I don't think that it was ever thought to be a national issue. I understand the arguments that are made under the 14th Amendment. I can't imagine that anybody, even the most expansive interpreters of the 14th Amendment at the time, thought that it would ever apply to something like this. And that gives me concern about the state of the federal judiciary. Now, that doesn't mean that you can't have marriage between two people of the same sex. I think we've seen other states that have adopted that through the legislative process. We've had other states that have adopted that through the judicial process of their own constitutions. I'm fine with that because I don't live there. And I think every state should have the sovereign right to make the decisions for how they want to live within their own borders. One of the things that troubles me about this amendment, or this resolution, is that it would call for an amendment to the U.S. Constitution that defines marriage. I see that a little bit different. Actually, I see it quite different from the other resolutions that we've been dealing with, because the other resolutions that we've been dealing with have been calling for amendments to limit the scope of the federal power and to return power to the states as it was originally intended. And what this proposal would do is it would actually, seems to me, it would actually put a federal requirement in the Constitution, and it would take power away from the states that most of us have thought that the states always had. Now, I understand, though, I understand the reason you do it is because the courts have said, well, this is a federal constitutional issue, and so you've got to respond to that. My preference would have been that the federal courts would have just stayed out of it completely, and that if there wanted to be state issues on it, then that would be fine. But I definitely do not like the way that the courts have decided this issue. I don't like the way that we've been moving, because I don't think that's where anybody ever thought that we were going to go with the U.S. Constitution. And that's one of the reasons also, because I had those questions about it, that's one of the reasons that I would have preferred that we not had a vote today, because if we were going to discuss this resolution, I wanted to hear testimony on that issue about whether it might be better not to have a U.S. constitutional amendment that defines marriage, but maybe we call a convention to allow the states or to propose an amendment that marriage is a state issue and that the states could define marriage. And so I wanted to hear testimony on that issue. Now, having said that, I'll say again, I do not like the way that the federal courts have been dealing with this issue. And so if we're going to have a vote, I'm going to vote for it, because in the spirit of what the senator from Williamsburg said earlier, there are only 5 of us here. And I think it's incumbent upon us to allow others to have some input in that process. I don't like the way the things have been going on this issue. I'm not sure that this is the best way to address it within our system of federalism, because I don't want the national government taking over on pretty much anything, and that would include this. So those are my comments. And I will vote to move it forward because I want to allow other people to have some input. But I would have preferred that we kept this just so we could have some testimony and so we could talk about those issues. But in any event, Senator from Berkeley.
Mr. Chairman, thank you for the opportunity to speak to the committee on this particular resolution. It was modeled after the federal amendment that has been proposed in Congress, I believe, in each of the last 10 years. So it's modeled after that, the congressional federal amendment to the Constitution that has been unable to garner the 2/3 support of both bodies. And just briefly about the issue of marriage. There's a religious aspect to it, and then there's a state compelling reason why why we have marriage laws. The religious aspect, that should be best left up to the churches and to those folks that of faith that hold to their beliefs, and we shouldn't infringe upon that whatsoever. But when it comes to the state, the reason that we have marriage, and it's called a marriage license, it is a license. Just as if you have a license for any other activity, there is a marriage license. And the reason the license is sought is to gain the state's protection under that covenant when marriage occurs. And all our laws in family court are based on the premise of a man and a woman involved in that licensure. Everything's built upon it. Case law has been built upon it. Court precedent has been based upon it. The reason the state had a compelling interest in marriage and in issuing a license for the activity of marriage has to do with the propagation of our species. It is what is in the best interest of the children. And you can't create a child absent of a man and a woman. So when the basis of law is a man and a woman, and now we're told through a federal judge that no, you have to change that, then it throws out of kilter all our laws that have been based upon the foundation of a man and a woman. And I think it's any debate on this, there needs to be a separation of religious faith and religious beliefs. That's a separate issue for someone else. But as government leaders, as those that make laws, it needs to be discussed as to why there is a license and why someone would apply for a license and why someone would ask for the government to be involved in their decision to have a union. And the reason throughout history has been, in a marriage, you are guaranteed certain rights and certain things that would happen in case the covenant is broken. And when the covenant is broken, that's when we have family court and judges, and it's all based upon the best interest, really the best interest of the children. But I just wanted to get that out there, and I also want to thank the subcommittee.
All right, so we've got a motion for favorable report on S31, and there is a second. So all those in favor of advancing S31 to the full Judiciary Committee, please raise your hand. All those opposed? All right, by 3-2, we'll send it to the full committee. All right.